It is always better to have one codified legislation than multiple one in order to deal with aspects of a company which can have a singular umbrella. Hello everybody, today we Muskan Pepania and Vadhur Bansal have tried to discuss the rationale for the existence of the Insolvency and Bankruptcy Code in India, which has been into effect since 2016 and its ordinance in the year 2020. Insolvency and Bankruptcy Code came into being repealing SICA, that is, Sikh Industrial Companies Act, and came into effect from 1st December 2016, taking into view the mistakes of the past and a wider scope aiming to resolve the issues via more effective provisions and implementations. It is therefore an act to consolidate and amend the laws having reorganization and insolvency resolution issues as the subject matter. Thus, the legislation holds the objective as follows: an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders, including alteration in the order of priority of payments of government dues, and to establish an Insolvency and Bankruptcy Board of India for the matters connected therewith or incidental thereto. Therefore, the provision of the Act shall apply to the cases of insolvency, liquidation, voluntary liquidation, or bankruptcy of a company, limited liability partnership, partnership firms, corporate persons, or individuals. Moreover, the Code acts as an authority to decide insolvency application within 180 days, to which 90 days extension is allowed. In addition to it, the code also provides fast track process of 90 days available for specified entities. Process under the code. Who can file an application? An insolvency resolution process can be initiated by financial creditor or operational creditor or corporate itself. Section 5 Clause 7 of the Insolvency and Bankruptcy Code states that financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. A financial creditor, either by itself or jointly with other financial creditors, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred. The adjudicating authority shall, within 14 days of the receipt of the application, ascertain the existence of a default from the records of an information utility or on the basis of other evidence furnished by the financial creditor. What is an operational creditor? In the event of late payment, operational creditor may send a request for notification to an unpaid debtor in the form of a copy of an invoice requesting the payment of the amount corresponding to the late payment to the debtor company in accordance with Form 3 of the Insolvency and Bankruptcy Code. The definition of operational creditor is given out in Section 5, Clause 20 of the Act. The debtor must send the notice to the mandatory creditor within 10 days of the receipt of the request of copy of the invoice. After the expiry of the period of 10 days from the date of delivery of the notice or invoice demanding payment, if the operational creditor do not receive payment from the corporate debtor or notice of dispute, the operational creditor may file an application to adjudicating authority in Form 5 of Insolvency and Bankruptcy Code for initiating the corporate insolvency resolution process. What is incorporate? As soon as default in payment occurs, a corporate applicant thereof may file an application to adjudicating authority in Form 6 of Insolvency and Bankruptcy Code for initiating corporate insolvency resolution process. It shall apply to matters relating to the insolvency and liquidation of corporate debtors where the minimum amount of the default is 1 lakh rupees. The corporate applicant shall, along with the application, furnish the information relating to books of accounts and such other documents relating to such period as may be specified, and the resolution professional proposed to be appointed as an interim resolution professional. Unlike earlier existing laws, Insolvency and Bankruptcy Code provides early trigger for insolvency resolution with limited grace period for payment, which situates the companies in a position where they have to be very watchful and vigilant with timely payment to the creditors. SICA, for example, requires a 50% erosion in the company's net worth to trigger a requirement for the board of the company to monitor and report the deteriorating position, while the RBI guidelines company requires loans that are overdue for 90 days or more to be declared as NPAs. The rationale for having the occurrence of a payment default as triggers is that the early detection of financial distress helps preserves value and increases the chances that a business can be saved. Thus, Insolvency and Bankruptcy Code has given the power of initiating a process for a company's insolvency proceedings in case of payment defaults to safeguard their interest and to keep the companies in check. Who cannot file an application? Corporate debtor undergoing insolvency resolution process or corporate debtor having complete corporate insolvency process 12 months preceding the date of making of application, or corporate debtor or financial creditor who has violated any of the terms of plans which was approved 12 months before, or the corporate debtor in respect of whom a liquidation order has been made. Ordinance of 2020. The central government on 5th June 2020 on Friday announced an ordinance named Insolvency and Bankruptcy Amendment Ordinance 2020. This ordinance stated that no company can be dissolved on account of default arising on or after 25th March 2020 for a period of 6 months, which can be extended up to maximum of 1 year from such date as per notification. It is also stated that no application for insolvency can be filed for the default arising during this period, though the default arising before 25th March are not exempted. The ordinance, which brought keeping in view the shutdown of operation because of lockdown announced because of pandemic attack of COVID-19, due to which every business organization is affected and many are shut down. So to protect such organization, the ordinance was promulgated. These changes in the code are made by inserting Section 10A to the code, which immediately suspends the operation of Section 7, 9, and 10 of Insolvency and Bankruptcy Code, where Section 7 is about enabling financial creditors to file for insolvency against debtor. Section 9 provides for application for insolvency by an creditor, and Section 10 is related to initiation of insolvency proceedings. Along with Section 10A, subsection 3 to Section 66 was added to state that no resolution professional should file an application with respect to such default against which CIRP has been suspended as stated in Section 10A. So, it can be concluded by saying that Insolvency and Bankruptcy Code is a comprehensive legislation with a speedy and specific procedure for dealing with the issue of insolvency. The time-bound nature of Insolvency and Bankruptcy Code is a win-win situation as the resources of the companies are placed at the right place in time, whether it is by payment to debtors or by winding up. The company does not keep running in losses or endless time period, causing a setback to the economy in whole and affecting the creditors individually. It is very well hoped for the implementation of the code to be as effective as expected and live up to its legislative intent.